from the judgments referred above, it is rather clear that a statute which affects substantive rights is presumed to be prospective in operation unless made retrospective either expressly or by necessary intendment. Stop. A statute which merely affects procedure unless a different intention is available is presumed to be retrospective. Stop. However, a statute which is procedural in its character but affects vested rights adversely is to be construed as prospective. Stop. Limitation provisions can be procedural in the context of a certain set of facts but may be substantive in a different set of facts on account of the fact that rights can accrue to both the parties. Stop. An accrued right to plead a time bar which is acquired after the lapse of the statutory period is nevertheless a right even though it arises under an act which is procedural, and a right which is not to be taken away pleading retrospective operation unless a contrary intention is discernible from the statute. Stop para. Though the legislature can legislate retrospectively, the same rule cannot be applied to the government exercising delegated legislative power, for the scope of their power is not coextensive with that of legislature. Stop. In other words, an executive government exercising subordinate and delegated legislative powers cannot make legislation retrospective in effect unless that power is expressly conferred, or such a construction appears very clearly in the terms of the act or arises by necessary and distinct implication. Stop para. Now let us consider the scheme of the act and to what extent the government will be entitled to exercise their executive power to extend the time for the registrar to complete with the enquiry under section 65 of the act. Stop. By the constitution bracket 97th amendment bracket close act 2011, the citizens right to form cooperative societies has been included as a fundamental right under Article 19 within bracket 1 within bracket C, and Article 43B has been incorporated for promotion of cooperative societies as part of directive principles of state policy. Stop. Part IXB has been incorporated containing articles. Stop. As per the constitutional scheme, state has to frame laws taking into account the provisions of Part IXB. Stop. In the state of Kerala, the act had come into force on 15/5/1969 and had been subjected to various amendments from time to time. Stop. The preamble to the act reads as under. Stop para. No doubt the time specified to conduct inquiry as contemplated under Section 65 is part of a procedure under the statutory scheme stop. However, the registrar has been authorized to complete the inquiry within a specified time and at any rate it shall not exceed 1 year stop. By virtue of the order aforesaid, government had exempted the society from the operation of Section 65 within bracket 5 until completion of the inquiry stop.